Bail. The critical pretrial question to be resolved is that the defendant will stay in prison while pending prosecution or if bail will be issued. An individual can be released on bail at any time after being detained by the police. Being given bail means that the person should be allowed to remain at liberty until the next stage of the particular instance. What is bail? Once you've been arrested, you will be freed on bail at the police precinct. It ensures that you're likely to be free to go home before the trial listens. If you are given bail, you may have to agree to terms such as you are still living at the same address as before. 2. You do not try to contact or reach out to some people like the claimant. 3. Handing over your UK passport to the police so you do not leave the country before the court's verdict. 4. Reporting at the police station at the decided time, for example, after every 2 days, a week or 10 days later. If you do not comply with these terms, you can be imprisoned again and taken to prison to stay before your court proceedings. 6. If you participate in a hearing before a magistrate's court, you may be given bail again till your trial starts. Police powers to grant bail. The police can release a defendant on parole whilst undertaking further investigations. It ensures that the defendant is released from police detention under the basis that he or she reports to the police department for a certain date in the future. The police may even grant bail to a suspect who has been accused of a crime. Under this scenario, the suspect is bailed free to appear at the nearest magistrate's court on a specific date. The determination on whether or not to issue bail is provided by the detention officer according to S38 of Rate, as amended by the Criminal Justice and Public Order Act 1994. The custody officer may keep refusing bail if the home address of the suspect cannot be found, or if there is a reason to think as to whether the home address given is accurate. Aside from that, the usual rules as to whether bail will be issued apply. Such requirements are laid out in the Bail Act of 1976 and are set out in the portion. If any person awarded bail by the police keeps failing to surrender to that bail, i.e., attending the next phase of the case, the police shall be given the right to detain them. Conditional bail. The Criminal Justice and Public Safety Act 1994 granted the police the right to enforce limitations on the issuing of bail. Examples of terms involve requiring the perpetrator to forfeit his passport, to return to the police department at regular hours, or to allow another citizen to speak up for him. Such provisions should only be enforced in order to ensure that the defendant surrenders on parole, does not perform an offense while on probation, and does not communicate with the prosecution or intervene in any other manner with the administration of justice. No police bail. Where a person has been charged with a crime, the authorities are not allowed to grant parole. They must put the suspect to the magistrate's court at the earliest practicable moment. If, as is generally the case, the magistrates cannot cope with the entire matter at the initial trial, the magistrates will instead make a determination as to whether the suspect will be granted bail or held. The problem as to whether bail can be issued can even be addressed by the court at some later point of the criminal trials. Statistics released by the Home Office suggest that the bulk of people arrested are called to trial rather than convicted. This ensures that the question of parole or detention is not relevant, they are immediately issued. Of those arrested, approximately 5 out of 6 are released on bail by the police awaiting legal hearings, and in reality, only a limited percentage of suspects are refused bail by the police. In these situations, the courts must determine whether to issue bail. The Bail Act 1976. It is a key activity, beginning with the presumption that the convicted party will be given parole, as this privilege is restricted in some situations. Section 4 of the Bail Act 1976 provides a standard right to bail, but the court does not issue a bail to the criminal until it is convinced that there are reasonable reasons for assuming that the suspect, until released on bail, does not report to custody, commits any kind of offense during their time on bail, interfere with the parties, witnesses, prosecutor, or anyone that is not allowed. The court can still deny bail if they have grounds to believe that the defendant must be held in jail for their own safety. When determining whether to issue bail, the court must weigh a variety of considerations, including determining how serious the case is and in what nature does the proceedings fall into, and the probable method of dealing with it. The character, antecedents, that is, past record, links, and relations with the community. The defendant's record of upholding the satisfaction of his duties under prior grants of bail in felony proceedings, in other words, whether or not he had been remanded on jail, on certain occasions. How strong is the evidence that the police has collected against the defendant? When the defendant is charged with a crime that is not punished by incarceration, parole may only be denied if the defendant has not already submitted to parole, and there are reasons to assume that he would not submit on this point. If there is no real prospect of a custodial sentence being handed down to the defendant if convicted, that defendant must be granted bail. The court can render the requirements appropriate for the granting of bail. These are close to the requirements that may be imposed by the police, which could require the submission of a passport and/or a visit to a police station. The court could often render a provision as to where the prisoner will live when on parole. This may be at the home address or at a parole inn. Sureties. The court, and the police, may necessitate a bail guarantee. A security officer is any individual who is able to agree to give a certain amount of money to the judge if the suspect refuses to come before the trial. This promise is known as a recognizance, and the no money will be charged if the defendant complies with all the conditions and does not fail any. The scheme is distinct from that in other nations, in particular the USA, where the probation officer will refund the money to the court until the suspect is released on bond, but receives the money back after the suspect returns to trial as necessary. Renewed applications and appeals. Usually, only one more application could be made to the magistrates if there is a change in the situation. The defendant may appeal against such a refusal to grant bail. Such an application shall be made to the President of the Crown Court. The defendant, who has been sent to the Crown Court for trial, may also apply for bail there.